I can say partially yes.
What's partial? What do you mean by partial?
I mean that
Did you not receive? Let's be clear.
at the moment I haven't received any call.
So it means your kids are okay with you not being there full time.
No.
Silence is God.
You just told the court right now that you did not receive anything. How long have you been staying here?
I've been detained for 25 days.
25 days. You haven't received any news from the family that's saying that your children are not well. So it's very clear that if they can leave for 25 days without any issues, it's confident for one to make a conclusion that they will be okay.
I do not.
Prosecution is now raising presumptions. So many presumptions, and primarily her question was not specific.
In which way, ma'am?
When she asked my client who takes care of the children, there are various forms of care. It's either financial support or who lives with the children. So my client consistently sought for clarity, but I could not intervene because I wanted her prosecution to elicit the truth. So my client further got confused because she was not specific. And my client had already stated that an examination in chief that he's the primary caregiver, but the children do not live with him.
Yes, that is understandable, ma'am, but the question, as I understand it, is to the effect that your client has been in custody for 25 days, not so? And the follow-up was to the effect if he, during this particular period, had received any message from the family mothers of the children regarding the children. Thank you. That is why I allowed the question. Anything further? Yes, please proceed.
Let's talk about your pending charge. About you being an accomplice on the pending charge. You said that one of the children that you look after was sick, right?
Yes. Not that he was sick. He was pretending to be sick.
And you still agreed to take this person to go buy medication, and you know that he was pretending to be sick.
Now that he has committed crime, I know that he was not sick.
When did you know that he was pretending to be sick?
After I committed that robbery.
So from your experience as a social worker, you were not able to detect that this person might be lying?
Objection. My client is only a social worker, not a medical practitioner.
Yes, ma'am. Your comment?
A social worker as an occupation, my worship, is able to detect basic psychological traits of a person. And since he works with children on a daily basis, I'm of the opinion that he was supposed to be able to have detected that the child was not truly sick. That's what I'm trying to establish.
Thank you. The question is allowed.
Thank you.
Well, Your Worship, I am not well familiar with the circumstances of when a person is pretending or not. That's not how I was trained.
But you have learned. You have said that you've got a postgraduate diploma, an honors actually. Sorry, Your Worship, an honors where you do some research, right?
Yes.
In social worker, right?
Yes.
So how are you not able to detect such traits from a child? Since you've got children, do your children never pretend to be sick?
In my experience, I have never encountered such thing. It was the first time. That's That's why I did not have any express of it or knowledge to pinpoint whether a person is pretending or not.
Okay. But then the person was sick, ne? But not sick enough. Because the person is the one that, the sick person is the same person that went into the store, right?
Yes, that's the person who was pretending to be sick.
And he walked into the store and bought himself medication.
Yes.
Okay. Mr. Matimba, for someone that's sick, and they call you that they're sick, and you provide medication at your work, right? To the children. Do you not provide medication?
No.
Okay. But
There
you
are
look
no-
after children, right?
Not like really.
Okay. For someone that's sick, do you perhaps believe that you were supposed to go get the person to buy themselves medication? Or were you supposed to buy the medication and deliver it to the person?
The person called me and I went to his place. And then he told me about his sickness. Then I drove him to the nearest supermarket. And as you know, that headache, it is not a chronic disease. So a person can walk through a shop because I was taking a call at the moment.
Okay. I see. A headache.
Yes.
Okay. No, it's fine. It's very clear that regarding the witness, you have provided the court with false information. And also in regards to your fixed address that you've provided to the court, it lacks permanence in such a way that it's very hard for one to trace you and locate you, as we have seen during the day when you were arrested.
Objection. Compound question. The question is confusing. Prosecution is talking about two different things: fixed address, alternative address. So we'll seek for permission from you, Your Worship, to make a remark to prosecution to be specific.
Use the mic so that they
Okay.
can.
Objection on the ground that the question as compound, it talks about two different things. Hence, we seek for permission from you, Your Worship, to make a remark to prosecution to be specific so that can answer honestly to the questions posed.
Your comment, ma'am?
I'm trying to get clarity, Your Worship, as it's still confusing to the court as to if the applicant has or does not have a permanent residence.
The question is allowed.
Thank you, Your Worship.
Okay, I can say I have a fixed address.
Two fixed addresses. Which one is fixed? Which one?
I did not say I have two fixed addresses.
Okay.
I have the one of 92 Avenue Manguini. That's the one at the moment I consider it to be as my fixed address.
Thank you. And yet, the police were not able to find you there. Thank you.
Can I please comment?
You can comment?
Yes, you can comment, sir.
As a person, Your Worship, like there are times you will not be in your residence. So I don't understand what you are saying when you say that I am not that they were not able to locate me, because as a person I have rights to move around.
You're correct. You've got the rights of movement. I agree. But the fact that no one knew where you were is concerning and alarming, because you were only located after you confided in your co-accused of your location. That's the only way you were located by the police. Before that, no one knew where you were. Not your grandmother, not the mother of your children, not your children, no one knew. So it's very clear that you were hiding to a certain extent. You were hiding from the law. You were running away from the law.
I cannot say I agree with you on that one because as a person, I don't like letting people about my trips.
Why is that?
That is my norm. Ever since I was young, I have never liked letting other people about my trip.
And yet you said earlier on during your evidence in chief that should they grant you bail, you'll comply with going to the police station and alerting the system that you are at this place. And now you're coming and saying that you don't believe in alerting people that you trust, like your family. How are you then going to ensure that your bail conditions are met if you are of the school of thought where you don't believe in alerting people where you are?
Your Worship, I would like to believe that the conditions of the court and then ordinary people are two different things. So the conditions of the court are all fundamental importance to me, like as those conditions of an ordinary person. That is why I put emphasis on the fact that I am going to comply with the conditions which the court will deem just.
Your Worship,
Any further questions, Ms. Sekula?
in my closing, Your Worship, of our cross-examination, Mr. Matimba, based on the fact that you do not believe in, it's your belief, we are all allowed to our different beliefs. You're not allowed to, you don't want to alert people of your whereabouts. It's very concerning, and the court needs to put some caution on the fact that he has said he will definitely comply with bail conditions to a point where, should he be asked to alert the police of his whereabouts, he'll do that. But yet he's a person who has very strong beliefs.
Do you still have questions to the witness?
No, Your Worship, I don't.
Reserve that for argument.
I rest my case.
Thank you.
Thank you.
Ms. Mulekwa, any examination? Yes, you may proceed. Any re-examination? Yes, you may proceed, please.
Okay, thank you. Mr. Matimba. Mr. Matimba, you have stated earlier on that you work as a social worker.
Yes, Your Worship.
Okay, and you've also stated that beyond you doing administration staff and doing audit and report, you also deal with children.
Yes.
So if I may ask, when dealing with children, do they all possess the same characteristics?
No, they don't.
Or they don't possess the same characteristics?
Yes, Your Worship.
Okay, Mr. Madino, in your examination in chief, when you were making inquiry about personal details, you further stated that you have a fixed address at the building owned by the Department of Social Development.
Yes, Your Worship.
Okay. You've also set out your alternative address.
Yes.
And you've also stated that you have started living at the so-called fixed address 4 years ago. You've been living there since 4 years, for a current period.
Yes.
So prior to that, where have you been living at?
I have been living at Mongobana Hospital View, House 1448. That one of my alternative address.
Thank you. So you said that there is a role that you play in the church. What role is that?
I am a treasurer.
A treasurer. Yes, thank you. Any question arising out of court question? Any question arising out of court question? Thank you. Any question arising out of court question? Thank you. Thank you, sir. You may stand up.
Madima, you went to Katani, you may take your seat.
You may proceed, ma'am. You may proceed. In regard to, I heard that there are 2 applicants. In regard to the other applicant, what is the position? Yes, then we proceed.
Greetings to the Honorable Court. I am Mbofana VL, the legal representative of the second accused, Mr. Sipho Chauke.
Thank you, Mokwa.
Sorry?
Muswana.
Mbofana.
Mufana.
Yes.
Thank you, ma'am. You may proceed.
With the permission of the court, Your Honor, we would like to call upon Mr. Sipho Chauke.
Mr. Chauke, in the witness stand, please.
May you please step into the witness box. Witness box.
Your full names and surname, please.
My name is Sipho Chauke.
Mr. Chauke, do you understand what is meant by oath?
Yes, Your Worship.
Do you have an objection in taking the prescribed oath?
No.
Do you consider the prescribed oath to be binding on your conscience?
Yes.
May you swear that the evidence you shall give shall be the truth, nothing else but the whole truth? If so, raise up your right hand and say, so help me God.
So help me God.
Thank you. Mr. Chauke, the court should warn you that anything you say in these bail applications may be used against you during the course of the trial. Do you understand?
Yes, Your Worship.
You are also obliged to disclose if you have any previous convictions or any pending cases. Failure to disclose that and it emerged later that you have previous convictions or pending cases, you may be convicted and be liable to be sentenced. Do you understand?
Yes, Your Worship.
Thank you. You may proceed there, ma'am. Mufana.
Thank you, Your Honor. Good morning, Mr. Sipho.
Good morning, ma'am.
How are you?
I'm good, and yourself?
I'm fine, thank you. I just have a couple of questions for you. Can you first please kindly introduce yourself to this honorable court?
My name is Sipho Chauke, a 35 years old man, and I'm a citizen of South Africa.
All right, so do you perhaps have a fixed address?
Yes.
And do you have any alternative addresses?
No.
All right, Mr. Chauke, do you have any relatives inside the Republic?
Yes.
And who are they?
My mother and my sister.
All right, and what about outside the Republic?
I do have.
So, have you ever traveled outside South Africa?
Yes, ma'am.
Where to?
Nigeria.
And what were the purposes of this trip?
It was about conclusion of a marriage.
So, Mr. Sipho Chauke, are you married?
Yes, ma'am.
All right, so where does your wife come from?
She comes from Nigeria.
Also, this means that the trip you had taken to Nigeria was for the level negotiations of your wife. Mr. Chauke, tell this court, where is your wife?
She's here in South Africa.
And is she employed?
No?
Do you and your spouse have any children?
Yes, we do have them.
How many?
We have 2.
And their respective ages?
The firstborn is 17 years old and the lastborn is 5 years old.
Mr. Chauke, are your children enrolled in any institution of learning?
Yes.
Can you please specify?
The firstborn is an University of Limpopo, and the lastborn was 5 years old, is in primary school, currently primary school.
Thank you, sir. So between you and your wife, who is responsible for the tuition fees?
Myself.
Only you?
Yes, ma'am.
Okay, okay, sir. Can you please tell us what will happen to your family if you are kept in custody?
I want to believe that they will suffer because I'm only a breadwinner there. I'm a primary caregiver.
All right, thank you, sir. Mr. Chauke, do you have any valid traveling documents?
Come again?
Do you have any valid traveling documents?
Yes.
Your Honor, we would like to put it to the court to state that Mr. Sipo Chauke here has submitted his valid traveling documents, including permits and visas, to the relevant authorities voluntarily. May I proceed?
You may proceed, ma'am.
Thank you, sir. Thank you, Your Honor. Mr. Chauke, are you employed?
Yes, ma'am.
What kind of work do you do?
I'm a professional teacher.
Where do you teach?
I'm from Training College.
Okay, so what grades are you teaching?
Come again?
What grades are you teaching?
Oh, it's 10 to 12.
10 to 12.
Yes.
And which subjects do you specialize in?
Mathematics and physical science.
Okay, so this brings me to my next question. Does your employer know that you've been arrested?
Yes.
And have they taken any form of action to replace you at work?
No.
And why is that?
Because the teachers or people who are like myself are very scarce.
Can you please elaborate further on that?
This is to say I'm teaching learners, or I will say I'm teaching people with disability together with those who are non-disabled. So for the one who has disability, it needs someone who has skill and experience.
Okay, thank you, sir. So what will happen, what is the effect of your absence at work if you are denied bail and you are remanded in custody? What would be the impact of that on your school?
Since we were busy preparing the grade 12 learners for the media exam, I want to believe that there's a danger that they will fail.
Thank you, Mr. Chauke. Can you please tell this court what will happen to your job if you are denied bail?
There's that possibility that the employment contract will be terminated.
Thank you, sir. So, do you perhaps have any disabilities?
Yes, ma'am.
Can you please kindly state?
I'm partially impaired, or I'm visually impaired, partially blind. I see, but I cannot see sometimes. This depends on weather. I can say when it's very hot, maybe in a case whereby the weather is above 35 degrees Celsius, I have a problem with my eyes. And again, this depends on the light adaptation. When I stay for a very long time where there's darkness, like I have a problem with my eyes, and even when it's too hot, where there's too much light, I also have a problem with my eyesight.
Thank you, sir. Do you perhaps have any assistance? Like, for example, let me put it this way.
In which way? By asking if he... Thank you. The question is allowed.
Thank you, Your Worship. As I was saying, Mr. Chauke, when, like generally, do you perhaps have any kind of assistance when doing your day-to-day activities?
Sometimes I do need help, sometimes I don't.
So, do you have an assistant for that?
Yeah, in a case whereby I need assistance, I do have a PA.
And this PA of yours, where do they assist you exactly?
With general things like general activities.
All right. Does the PA assist you at work and at home, or only at work?
I sometimes ask him at home, but usually help me at school, more especially in a case whereby I cannot see.
All right, sir. Now that brings me to my next question. Can you please tell us what are the conditions in the prison cells? How are they, if I may say?
Come again?
How are the conditions inside the prison cells where you are remanded?
It's tough because I can't easily access my medications, and again there's too much light, so it affects my eyesight. The space is very limited. I cannot use my walking stick when I can't see. So, to be honest, the condition is not favorable to me. I'm struggling a lot. I even wish maybe I can die, but it's just that my children and the public who I want to help outside there will suffer.
All right, sir. Do you have any assistance inside the prison cells?
No.
Mr. Chauke, you stated your condition, like your conditions to your blindness. You stated that it ranges from weather, something about the weather and how it affects you, and light and darkness. So I would want you to clarify to the court, how are those conditions in the prison cells going to affect your eyesight?
Because this happened continuously, there's a danger that I'll end up being a total blind person, like my eyesight will go completely.
Thank you. Moving on, do you have a pending case against you?
Yes, I do have, ma'am.
And what is the case about?
Robbery with aggravating circumstances.
Where is it?
Ma'am?
Where is it? Like, where is this case happening?
It happened at Mokopan.
So can you please tell us, have you perhaps been granted bail for this crime?
I was released on warning, ma'am.
On warning. All right. Thank you. So do you have a previous conviction?
Yes, I do have, ma'am.
What was the crime about?
The offense was assault.
And who was the victim in this crime?
The neighbor.
Mr. Chauke, were you convicted?
Yes.
And what was the sentence?
I was just given a fine of 1.5.
Mr. Chauke, I would like to remind you, sir, that when you stood right there, you took an oath. I need you to keep that in mind. Sir, do you know any of the witnesses in this matter?
No, ma'am.
All right, thank you. Sir, if this honorable court were to grant you bail, will you be able to afford it?
Yes, ma'am.
Lastly, can you please give this court the reasons why you should be granted bail?
Okay, ma'am. I'm asking a bail because I'm afraid that I lose the job, as I've said, that my employment contract may be terminated. This, I think, will have impact on my family, more especially to the people who depend on me, and also myself, ma'am. I'm a breadwinner for more than 5 stomach, and again, there are people that I'm assisting outside there, as I've indicated that I'm a teacher who I help learners, and I've indicated that we're busy preparing grade 12 learners. And again, ma'am, I'm afraid of my eyesight here in prisons, as I've said, that the condition is not favorable to my eyesight. So I'm asking the bail on those grounds, ma'am, and I'm going to plead not guilty because I didn't commit the crime.
Thank you, sir. No further questions, Your Honor.
Good morning, Your Worship. How are you, sir? My name is Pahlani Lisiba. I'll be cross-examining the applicant too. Mr. Chauka, how are you doing, sir?
I'm good, and yourself, sir?
I'm fine, thank you very much, sir. Do you know why you are here?
Yes.
Do you understand why you are here?
Yes.
Okay, first, let me just be precise so that we can finish. During your evidence in chief, you said that you have relatives in Nigeria. Is that correct?
Yes, sir.
How often do you visit them?
I only went there once.
When was that?
The time I went there for the conclusion of a marriage.
Yes, when was that? Can you specify, maybe 20 years back or 10 years back?
Oh, that was 20 years back.
20 years back. How long have you been in your marriage?
I've 20 years now.
We are 35 years. Are you
Yes.
30? So you are married at 20 years. When we are 15, actually, because we are 30.
Your Honor? Objection, Your Honor. Relevance?
Yes, what is the objection all about, ma'am?
It's about relevance. Counsel is asking about when my client was married, and I don't see any relevance to this matter in question.
Well, the question is relevant in the sense that he went to Nigeria to get married, and he asked him how often he visit Nigeria. Once when he got to the married. When was he married? It's very much relevant. The question is allowed.
All right, Your Honor.
So, are you 35 years?
Yes, sir.
So you were married 20 years back.
Yes, sir.
That is when you are 15 years.
Yes, sir.
All right, thank you very much, sir. Can you explain to the court how often do you communicate with the relative from Nigeria?
I don't really communicate with them.
You don't communicate with them at all? Do you communicate? Don't you communicate with them at all?
Come again?
Don't you communicate with them at all?
I do communicate with them, but not usually.
When last did you communicate with them?
I can't remember.
So what about your wife? Does she obviously she will communicate with them because she's a family. Is that correct?
As you're saying, I will believe so.
Your wife, does she communicate?
You're the one who said that I believe so.
What about, tell me the truth. No, I want you to tell me. Does she communicate or not?
Is he not in a position to answer that? Your client. Why?
He's not the wife.
Your comments, eh?
I think it is relevant because they are married, so it's much relevant because they are married. So I don't think if he doesn't know, it might be possible, but it's a wife. It's highly possible that you know.
Yeah, how will he know if he's at work?
No, they stay together. So I don't think.
Are you communicating with, is the wife communicating with the relative in Nigeria, sir? Do you know or you do not know?
I do not know because I don't touch your phone.
You may proceed, sir.
Okay, thank you, Your Worship. Then, in case of funerals, anything, you don't attend there in Nigeria. That's correct?
Yes.
Okay, thank you very much. I'm quite aware that you might know that passport need to be renewed. So, in our evidence, Your Worship, we have in Exhibit A, we have this passport is updated and it is up to date. So, in general, the passport must be updated in 10 years. So the last time you went to Nigeria, it was 20 years back. So why did you renew your passport if you don't go to Nigeria usually?
Because I had no intention to go to Nigeria.
Why did you renew your passport?
I had no intention to travel outside South Africa.
Why don't you renew? That's the question. Why did you renew? Can you answer the question?
Prosecutor, can you please repeat your question?
Why did you renew your passport if you don't intend to go to Nigeria or you don't travel outside the country?
Well, when my man says me, well, I don't remember me renewing the.
It's up to date, Mr. Chauke. We have it in our Exhibit A.
That's what I'm saying. I don't remember myself renewing.
Who renewed on your behalf? Who usually renew on your behalf? You have to consent to everything that has to do with the documentation. How come you don't know?
Perhaps during the days where I was blind, maybe someone came and fetched it.
On your behalf. How come you have to consent, Mr. Chauke? They cannot just do as they please with their documentation. Documentation is very important. So there's no one who can do it without your consent.
Yes, I agree with you, but that's what I'm saying. Perhaps that maybe during those days I was blind. Remember, when I'm blind, I need someone to help me. So that's why I'm saying perhaps during those days, maybe someone can fetch it, because with me, I don't remember myself renewing my traveling document.
What kind of disability do you have, Mr. Chauke?
I'm visually impaired.
So can you hear?
Yes.
Yes, when they consent, they'll tell you. Then it's either you agree or not. So how did they didn't tell you?
Come again?
When you consent, they have to tell you, then you agree. So how did you know about the consent? Because they can tell you, then you approve the agreement between you and the PA.
I don't remember myself signing any consent form with regard to that.
So you don't know how your passport was updated?
Yes.
Are you trying to lie to court so that you can run to Nigeria in case you're released on bail?
How can I run? Because I've submitted my documents to the police.
Yes, yeah. On this case, you don't know anything about your documentation. So we cannot even know what will happen if you go out. You might run away from the country illegally, because in case we don't understand your...
Objection. My client has already stated that he doesn't recall when he updated his passport date. He didn't say he doesn't know when he updated.
Comment, Mr. Padlani?
Yes, then if it's like that, then that means everything about him you can forget. Then he cannot justify. He must justify for everything. I think he must justify. If he's going to say, I cannot recall, that means with everything. Even if he commit the crime, he say, I don't recall. Then it doesn't justify. So I don't really agree to that one.
He has already answered the question. You may proceed.
So we believe that we are a flight risk. Your documentation is not specific, so you might as well, if you get the bail, run away. So in this case, you failed to disclose why you renewed your passport. So you didn't give us the relevant, or you didn't justify.
Objection,
enough.
Your Honor. Objection.
Yes.
On the issue of documentation, we did caution the court that Mr. Sipho Chauke has submitted these traveling documents to the relevant authorities. And again, on the issue of the traveling documents, he has already stated on the renewal that he does not recall. And those questions, counsel, have been asked and answered.
Yes, that has been answered by the council is putting to him that
Yes.
he is a fly risk. Is
When
what
he
the
renewed,
opposition.
He had intention the time he was renewing, but he forgot, but he had intention. That is to go outside.
You may reserve that for argument, Mr. Patlane.
All right, thank you, sir.
You may proceed.
Mr. Chauke, during the evidence in chief, you provided that you have visual impairment. Is that correct?
Yes.
And then you further provided that during detention, you sometimes, in the specific way, I can say you sometimes experience visual decline. Is that correct?
Yes.
So that means that you occasionally get that visual decline while you are in holding cell. Is that correct?
When I was?
You occasionally get affected by the.
Objection, the question is asked and answered in cross-examination.
Yes, I want to confirm.
Examination, please.
I'm sorry?
The question was asked and answered.
In?
Examination,
Yeah, the council is entitled for cross-examination. If he wants to clarify that, he may proceed. The question is allowed.
Yes, you provided that you occasionally get visual decline when you are in holding cell. Is that correct?
Yes.
Do you understand what is occasional?
Yes.
Can you just specify to the court what do you mean by occasional?
Not always.
Yes, that is after some time, correct?
Yes.
So how is that affecting your, let's say outside, let's talk about outside. When you're outside, is it occasional or is it frequently?
It's not occasional.
Is it frequent?
Define frequently for me so that I will understand.
That
and
is
I'll answer the
in frequent intervals. That means in short period of time. That means when you're outside, that eyesight decline it happens after a short period of time. Is that correct?
Will you allow me to explain the condition again?
No, I'm asking you to confirm. You confirm that inside it is occasional. And then I'm asking outside, is it occasional or frequent? Can you answer the question, please?
Okay, my eyesight depends on weather, so I cannot easily answer that question.
No, you are the one experiencing it. You have to answer.
It depends on weather. If it's very hot, it does affect it. But if the weather is moderate, I'm okay. I don't have a problem with my eyes.
Then in the holding cell, do you occasionally experience it? Can you just confirm?
Depend on weather.
No, since you how long have you been in holding cells?
Come again?
How long have you been in holding cells?
I have 25 days.
25 days. Yes, in that 25 days, can you tell the court how, was it occasional, that eyesight decline?
Well, I won't say occasionally.
But you said occasionally, sir. Are you trying to lie to the court?
No.
So why you said occasional, now you are changing. What is your statement?
As I've said, the darkness and the light, it does affect my eyesight. So that depends whether if there's too much light or if there's darkness.
Okay, thank you. Then, during evidence in chief, you provided that you need medication on a daily basis. Is that correct?
Yes.
So, in that 25 days, how did you manage without medication?
I called my wife and then she brought them. The one that I have for now, or the one that I was using, she brought them. But the problem, I'm taking this medication from Pretoria. So I might have a problem that, or I'm afraid that I might not get them.
Is your wife working?
No.
So how did you buy the medication?
Hello?
How did you buy the medication?
I do buy medication. I had medication before because I buy more than enough usually, of which now they are finished.
Okay, then you said while you are in detention, nobody was helping you, is that correct?
Yes.
But do you understand that your situation is not exceptional? Because within the holding cell, there are healthcare services that can assist you. Did you know about them?
No.
Did you ask about them?
Yes.
Then what did they say?
They kept on promising, but they never brought one.
Okay, thank you, Mr. Chauga. Since you said they promised, it means they can. It's possible that you can get the medication, so there's no need for you to go outside. That issue can be resolved within. So that is not exceptional. You cannot go out for that reason because inside there's assistance. Is that clear?
Is it a question?
No, I'm providing to you that it's not possible that you go out because inside, I'm answering you that inside there's assistance, so there's no need for you to go outside.
Do you have any response or comment, Mr. Chauke?
Yes.
You may proceed, please.
I would like to speak about my marriage.
No, regarding what the council is saying.
For now, I think if the court decide not to grant the bail, or if you say that I will be kept in jail until I think I will have a problem because I've indicated that my eyesight is declining due to those conditions. And now, because there's no one who is assisting me, I'm immovable. I cannot move around the jail because there's no one assisting me. So I feel like I'm struggling here because my movement within the premises is very limited because I've indicated that I cannot even use my stick.
All right, but then I provide to you that it's possible that you get assistance from inside. So there's no need for you to go outside. So let's continue, Mr. Chauka. How long have you been a teacher?
I've got 7 years.
7 years. That means before you get to be a teacher, you were in your marriage.
I was?
Before you get to be a teacher, you were in your marriage, correct?
I was?
Before you became a teacher, you were in your marriage.
Yes.
So before you became a teacher, how did you provide for your family? How did your family get assistance?
I used to get money from the charity, like as I do disability awareness.
All right, from charity.
Yes.
So will you agree with me if I say charity is very helpful and it is also still helpful even now?
No.
How is it possible? Because we are no longer depending on it.
Because even those times, no donations because we're just only depending on donations.
But we are able to survive.
Yeah.
So it means they were helpful.
No.
But you managed to survive. Isn't that helpful?
The reason I'm saying no is because, like, while I was doing those charity, I further look for the job, the one that I have now, as a teacher. And now this one is helpful because I'm not in need of another one.
No, we are not talking about now. We are talking about before you get employment. So that is almost 13 years of not being employed. So you managed to survive through charities.
Is it a question?
Yes.
Can you refrain it?
I'm saying since it was 13 years of you not being employed. It managed to help you within that 13 years. So can't you consider that helpful?
No.
But you managed to survive 13 years, sir. Isn't that...
Is it a question?
Yes, you managed to save 30. Isn't that helpful? I'm trying to confirm with you, sir.
Oh, okay. Maybe let me give the reasons why I'm saying it was not helpful. I'm saying it is not helpful because it was not helpful because I used to go to my mother and ask food. Sometimes we used to sleep with empty stomach. So that's the reason I'm saying it was not helpful.
Okay, we move, Mr. Chowk. Let's focus on our family circumstances. You provided that you have 2 children, is that correct?
Yes.
And you provided that you are a caregiver.
Yes.
Do you understand what is a caregiver? Primary caregiver. Can you
Yes.
just elaborate to the court what is a primary caregiver so that we can able to
Yes,
understand
yes.
Your duty as a parent?
Come again?
Can you elaborate to the court what does it mean by being a primary caregiver?
According to my understanding, I'm the financial supporter, I'm the breadwinner there.
No, that's not correct, Mr. Primary caregiver is someone who takes care, especially your children, in daily basis. It means that when we are at work, the person is taking care of the children. So are you taking care of the children or are you working?
I'm taking care of the children
You are
and
not
I'm
working.
working.
We are taking care of them while we are working at the same time.
Yes, because I knock off at my work.
What time are you knocking off?
2:30.
So you consider yourself as a primary caregiver?
Yeah, because by those times they're at school. We usually, when they're together, more especially the primary one.
Okay, thank you, Mr. Chairman. Do you have emergency savings?
What?
Emergency savings?
No.
You don't have emergency savings. You provided that you have a PA in your house.
Yes.
Is that PA fit enough to seek for employment?
To do?
To seek for employment?
To seek for employment?
Yes.
For?
No, is he fit enough to seek for employment?
Maybe I don't understand the question. Can you please refrain it?
Let me make it clear. Is he fit enough to seek for employment?
Yeah, but still he will not understand because the PA works for him, not so.
Yes.
Can you try to be clear so that he can understand?
Maybe, let's say, can he assist your family in your absence by any means?
I don't think so.
You don't think so? Is your wife fit enough to seek for employment?
To seek employment? Yes.
So in your absence, she can maybe look for a job and support the family. Is that correct?
Come again?
Is she fit enough to seek for employment, then she will work for your family in your absence?
She helps the family in my absence?
Yes.
Only if she will get it.
Yes, is that possible? Is she fit enough?
Yes.
So you see that we are not needed outside. We can stay and it's possible that she can get employment while we are in.
Is it a question?
Yes, I'm providing to you that you are not needed outside because your wife can look for employment and work for your children on your absence because she's fit. Do you agree?
Partially.
What do you mean by partially?
I mean like she can able only if she will get a job. But remember, this South Africa, jobs are very scarce. Together with the COVID-19, many people lost their jobs. So I'm afraid that she will get it.
But it's possible that she get employment, correct?
Yes, it's possible.
Therefore, you are not needed outside. She can look for employment and support your children. So as an experienced teacher, how does the school help children who cannot afford themselves?
Come again?
As an experienced teacher, how does the schools make sure that they provide for students who cannot help themselves? Students from poor families.
Yeah, but what is the relevance of the question
The relevance
in
is
this bail application?
the young child is trying to support, so I'm trying to establish if the child can get assistance.
His child?
Yes.
Okay, thank you.
Maybe.
According to your experience as a teacher, how do schools make means to ensure that poor students are being taken care of?
Well, they sometimes give them those food from school, but this happen once in a year, more special during the end of the year.
So they do assist poor students, poor learners.
Yes.
So it means that it's possible that your child can also be assisted. Do you agree?
I don't agree.
But you said they are assisting, so why don't you agree? Because it doesn't suit you.
Because they only give them once at the end of the year. Now it's May.
Or at your school?
Yes.
Okay, but usually they get assisted. You agree with me?
At the end of the year, yes.
Okay, then your 17-year-old child, you provided that is in university, is that correct?
Yes.
Is there any means that you can get funding without you assisting?
As for now, I don't really understand the question.
Can you get funding without you assisting? Is that possible?
I don't think.
Can you please look at the fact that our client is a school teacher who does not work in the Department of in university, so he does not know of any information pertaining to the course.
Mr. Patlane?
Or I provide to him that there are fundings for university students, so he's not needed outside. There are many funding schemes out there for university students. So it's possible that the firstborn get funding without him assisting.
Yes,
So
what
that
is your
is not
response, Mr.
exceptional.
Chauke?
I hear you.
Yes, that do you realize that that is not exceptional?
Come again?
Do you realize that the issue is not exceptional? It's possible that your child can get funding without you assisting.
I don't think so, because now is during the year. Because as far as I know is that people apply funding such as NSFAS around September, November, December, January, like for the upcoming year. So for now, I don't really agree with you. That's why I said I hear you.
Yes, still May, so you still have alternatives. There are many fundings. It's not only NSFAS. So there are many funding schemes that you can apply. You must just check. So you see that it's possible that you can get assistance without you.
I hear you.
Yeah, thank you very much. It means that we are not needed outside. So let's go to your previous convictions. Can you stipulated that you were previously convicted for assault, is that correct?
Come again?
You stipulated in evidence in chief that you were convicted for assault, is that correct?
Yes.
Was that a sentence? What kind of sentence?
I said I was given a fine of 1,500.
Okay, can you just elaborate to the court what happened during the time of the assault?
As to what?
Yeah, what happened?
Okay.
What have you done? What happened?
Okay.
Did they provoke you or provoke the person?
Okay, they were always teasing me, calling me Sfofu, and as a result, we ended up fighting because I was against it, so ended up fighting.
Oh, so you lost temper, then you fight. You did fight.
Come again?
So you lost temper and fight.
I can fight because I fought.
Yes, you fought. Is that correct?
Yes.
So you realize that a person who has short temper is very dangerous to the society. It means that you are endangering the society. That's why you assaulted the person and you were arrested for you're always involved in violence crimes. It means that firstly you were convicted of assault. The second one was robbery with aggravating circumstance, and now you are still involved. You see how you are a danger to the society.
Well, I'm not short-tempered, and remember with my cases, I'm not yet convicted.
You said you're convicted for assault.
No, I mean the pending one and the one that I'm applying a bail for. I'm not talking about the assault.
But I asked you if you lost temper and you fought, and you said yes. So did you lose temper or not?
Come again?
I asked you if you lost temper and you fought, and you said yes. So did you lose temper or not? Do you understand that you are giving evidence under oath?
Yes.
So why did you say you lost temper, then now you are changing? Are you trying to lie to the court?
I said I can fight because I fought. I didn't mention part, or I didn't answer the part of short-tempered.
So you do realize that you involved in violent criminal crimes? Do you realize?
Come again?
Do you realize that you are involved in violence crimes?
Yeah, I realized that I was charged with various crimes.
Okay, thank you. No further question, Your Worship.
Thank you. Ms. Mufana, any re-examination?
Yes, Your Honor.
Thank you. You may proceed.
Thank you, Your Honor. Mr. Chauge, you stated that prior to you working as a teacher, you relied on donations. Is that correct?
Yes, ma'am.
Was it enough?
No.
You also stated that your wife is unemployed. Has she ever sought employment before?
Yes.
And was she successful?
No.
Mr. Chauke, you also talked about your school being able to assist children, right?
Yes.
And you said it happens how often?
Once in a year.
Once in a year. So, sir, as a parent, do you think that this assistance will be enough for your young child?
I don't think so, ma'am.
Thank you. And also, on the issue of NSFAS funding, you have a child in a higher learning institution, right?
Yes.
And they're not funded.
Yes.
You take care of the tuition fees yourself.
Yes.
And for which year is your child doing?
Come again?
Which year is your child in?
First level.
First level.
Yes.
So you've been taking care of the tuition for now.
Yes.
So do you perhaps think in the near future you would apply that NSFAS for your child?
Come again?
In the near future, will you apply for NSFAS for your child?
I'm not sure.
All right, lastly, on your assault incidents, right, you were convicted of that crime, you've already stated. But my question is, have you ever been in any altercation after that incident?
No.
Thank you. No further questions, Your Honor.
Thank you, Ms. Mfana. Thank you. Is that all?
Yes, Your Honor.
Thank you, sir. You may stand down.
Sipo Chauke, you may be seated.
Your Honor, we would like to believe that the first applicant and the second applicant have adduced the necessary evidence, which is the exceptional circumstances in which the interest of justice permits them to be released on bail.
Before we come to that, do you have any witnesses to come?
No.
Any further witnesses?
No, Your Honor.
Are you closing your case?
Yes, Your Honor.
Thank you very much.
Thank you.
Ms. Sekula, the applicant's case closed.
Thank you, Your Worship. This time the court will be addressed by Ms. Matilda, if the court allows.
Thank you. Ms. Matilda?
Your Worship, I would like to introduce the evidence, if it pleases the court. The evidence will be presented in a form of affidavits, which are compiled by the investigating officers. The first affidavit will be provided by Mr. Tepo Moshaidisa, and the second affidavit will be presented by Mrs. Lizzie. As it pleases the court,
You may
they may
proceed.
proceed.
Good morning, Your Worship.
Morning.
How are you? Your Worship, the state is in the position of affidavit made by Mr. Sithole to oppose the bail application of the applicant number 1. If it pleases the court, may I read the affidavit? May I read the affidavit into the court's record?
You may proceed, sir.
In the Manguan Regional Court for the District of Capricorn, Limpopo, case number A462-2021. The matter between Matimba Events Mukachani, first applicant, and Sipo Chauke, second applicant. This is the state, the respondent. Affidavit in opposition of bail application as contemplated in section 6011, subsection 11A of the Criminal Procedure Act 51 of 1977. I, the undersigned, Cyril Sithole, declare under oath as follows. I am the investigating officer in the above mentioned matter, aged 24 years, born on the 14 June 1998. I am a South African citizen. I make this affidavit freely and voluntarily without being unduly influenced or coerced in my sober senses. I am permanently residing at Teflop, house number 222, Polokwane, Limpopo Province, Sovenga 0727. I declare that this is my fixed address. I plead with this court not to release the applicant on bail. I respectively submit, as I will demonstrate herein, that the interest of justice does not permit the release of the applicant on bail. The facts here contained, save where expressly indicated to the contrary, are within my personal knowledge and belief and are both true and correct. The purpose of this affidavit is to provide the Honorable Court with the circumstances and the grounds to address the factors that the interest of justice do not permit the release from detention of an accused. In terms of Section 60 subsection 4 to subsection 9 of the Criminal Procedure Act 51 of 1977. The grant are as follows. The reason for the arrest. Both applicant number 1 and applicant number 2 were arrested on the 17th of March 2022, which was after were linked and charged with robbery with aggravating circumstances, which is Schedule 6 offenses. That took
place at Mankweng Plaza, Teflop. Both applicants have pleaded not guilty to the charges mentioned above. Pending matter, the applicant one is facing another charge of robbery with aggravating circumstances that occurred at Mokopan. He has made his first appearance for this offense on the 1st of April 2022, and he was released on warning. This matter is still pending. He is due for a bail application in Mokopan. Based on this information, it's crystal clear that the applicant does not respect the law and is not remorseful of his action. The warning did not deter him from committing another offense of the same kind. This serves to show us that there is a greater opportunity, there is a greater probability that should he be released on bail, he might continue with omission of similar offense. No fixed address, evasion of trial in terms of Section 60, subsection 4 of the Criminal Procedure Act 51 of 1977. The accused does not own any property within the country. The two addresses he provided us does not belong to him. One of the properties that he provided us, it belongs to the employer, the Department of Social Development. The property is situated at number 92 Avenue, Mankweng. The second property is owned by his grandmother and is situated at house number 1448, Hospital View in Mokopan. As a result of no permanent address, the arrest was difficult and it took a while before officials could locate him. On the day of arrest, the accused was not found at either of the two addresses. He was only found after location was confirmed by his co-accused. The applicant was found on the road to Pretoria around an area called Kudoscope. This is an indication that should the applicant be released on bail, it will be difficult to locate him, and as such, there is likelihood that he might attempt to evade his trial, influence or intimidate the key witnesses. According to information in the police document, the following was noted. The charges emanate from an incident of robbery of business building at Mankweng Plaza. The employer at the shop was forced to open the safe for the two robbers after have threatened to kill her by pointing guns at her. They took the money and snatched the phone and made run for it. I quote, "The two men were not covering their faces in any way before making away with the stolen money. They told me that they are not afraid of police and this was not their first robbery. They continued to say that because I saw their faces, if I ever called the police on them, they will kill me and my whole family, and that they know where I live." I close the quotation, my worship. The applicant is very familiar with the identity of our key witnesses and all evidence that she has against them. The investigation against the applicant has been completed, and this key witness has already made a statement and agreed to testify. From the way in which the applicant have showed the court how less he thinks of the law, one can only conclude that even if he is released on bail with conditions, he will not adhere to those conditions. I submit that in terms of section 60, subsection 11A, that the interest of justice requires the applicant to further and continued incarceration, given the seriousness of the charges against him, unless he is able to satisfy the court that exceptional circumstances exist which, in the interest of justice, permit his release. Therefore, I submit that there are no exceptional circumstances which, in the interest of justice, warrant the applicant's release on bail from detention in terms of section 60 subsection 4 and section 60 subsection 11 of the Criminal Procedure Act 51 of 1977. Dated at Mankweng on the 6th day of May 2022. Your Worship, the affidavit is duly signed by the respondent and commissioned by the Commissioner of Oath. If it pleases the court, may I hand the affidavit into the court.
Ms. Sikula, Ms. Mulekwa, Ms. Mufana, any objection if the affidavit is admitted into evidence?
No objection, Your Honor.
No, I will take that there is no objection also from the other ones. Thank you. The affidavit is admitted into evidence as Exhibit A.
As it pleases the Honorable Court, my name is Lizzie Mafongo, and I'm going to be presenting the affidavit made by the investigating officer for accused applicant number 2.
Thank you.
If it pleases the court, I'd like to ask that I read out the affidavit so that it's noted and it's in record.
Thank you, ma'am. You may proceed.
As it pleases the court, in the Mankweng Regional Court for the District of Capricorn, Limpopo, case number A42/2021, in the matter between Matimba Evans Mkacha and Sipho Chauke versus the state. An affidavit in opposing of a bail application as contemplated in section 60, subsection 1, subsection A of the Criminal Procedure Act 51 of 1977. I, the undersigned, James Mulepo, declare under oath as follows. I am the investigating officer in the above-mentioned matter, age 27, born on the 4th of June 1995. I am a South African citizen. I make this affidavit freely and voluntarily without being unduly influenced or coerced and in my sober senses. I am permanently residing at Teflo house number 432 Polokwane, Limpopo Province, Sovenga 0727. I submit that this is my fixed residential address. I hereby act in my capacity as the state representative in the SAPS Office of the Mankweng Regional Court. I seek from this honorable court not to release the applicant on bail. I respectfully submit, as I will demonstrate herein, that the interest of justice does not permit the release of the applicant on bail. In any event, the dictates of fairness and justice in view of the peculiar facts herein warrant that the applicant should be deprived of his liberty and that he should not be released on bail. The facts herein contained, save were expressly indicated to the contrary, are within my personal knowledge and belief and are both true and honest. The purpose of this affidavit is to provide the above honorable court with the circumstances and grounds to address the factors that the interest of justice does not permit the release of the applicant from detention. In terms of the provisions of section 60 subsection 4 and section 60 subsection 9 of the Criminal Procedure Act 51 of 1977. Herein I will state out the circumstances with which the affidavit is relied on. The first one is flight risk. The applicant is married and lives with a Nigerian woman with which he has a traveling documents, particularly a passport. The applicant is likely not to stand trial, and there are chances that he will evade the ends of justice by undermining the objectives or the proper functioning of the criminal justice system, particularly the bail system. This is because it was difficult to track down Mr. Sipho Chauke, who's the applicant, and he travels to Nigeria a lot. He seems to have made an impression with his in-laws and has made so many friends there as a result. He treats Nigeria as his second home. Attached are his valid passport that shows his frequent visits to Nigeria. Pending matter. The applicant is facing another similar charge of robbery with aggravating circumstances, which he committed in Mokopane and was released on warning for. And because he has a pending matter on the same offense, it is impossible to know whether or not the applicant will not commit any other offense if his bail is granted. As a result, if the applicant is released on bail, he will endanger the public safety, and I am of the opinion that the applicant is highly likely to commit another robbery as he did prior to the offense before the Honorable Court. I therefore contend to this Honorable Court that if he was released on warning and the warning did not deter him from committing another similar offense, he is more likely and certainly will undermine the functioning of the criminal justice system. Prior conviction. The applicant has a previous conviction of assault for which he was sentenced 5 years ago. This reflects on the applicant's history of violence. As a result, he is more likely to evade the ends of justice by threatening witnesses. Intimidation or influence of key witnesses. Because of the applicant's violent nature and pending trial, this demonstrates a pattern of disobedience with the law and its non-deterrent effects on him. And as a result, he is more likely to interfere with the state witnesses. In addition to that, Your Worship, the fact that the eyewitnesses and the state witnesses both live in the area of Mangweng, of which is where the applicant is residing, it is clear that it will happen that the applicant will intimidate witnesses if released on bail. I am aware that the applicant is facing the charge of robbery with aggravating circumstances, which I vehemently, in my belief, and also as far as I'm aware of the evidence, the applicant will be found guilty during the trial. I further contend that the state case is strong and does not raise a serious doubt. I humbly request the Honorable Court not to release the applicant on warning or bail. If released on warning or bail, he will abscond or evade the trial. The applicant will interfere with investigation of the state witnesses. He will jeopardize the functioning of a bail system. He will endanger the safety and security of the community members. He will disturb public peace and order. He will not adhere to any reasonable conditions that may be attached to bail. I submit that in terms of Section 60, subsection 9, that the interest of justice does not permit the applicant, and furthermore, his continuous incarceration should be given the seriousness of the charge that are presented before this Honorable Court. Therefore, I submit that there are no exceptional circumstances which, in the interest of justice, warrant the applicant's release on bail from detention in terms of Section 60, subsection 11A to Section 60, subsection 11B of the Criminal Procedure Act. This was dated at Mangweng on the 6th of May, 2021. Your Worship, the affidavit has been duly signed and commissioned, and I would like to permission to give it to you as it pleases the court. Thank you.
Ms. Mufana, any objection if the affidavit is admitted into evidence?
No, Your Honor.
Thank you. The affidavit is submitted into evidence as Exhibit B.
Your Worship, this will be the end of the state case, and the parties will state their closing statement should the court permit.
Thank you, ma'am.
Thank you.
Ms. Sekula? I'm sorry. Yeah, Ms. Sekula. I want Ms. Molegwa. Ms. Molegwa and Ms. Ma'am?
Thank you, Your Worship. On the applicant side, the person who will be doing the closing argument is Mr. Madeo.
Thank you. Mr. Malibu?
Morning, Your Worship.
Morning, sir.
Before I proceed with the closing arguments, I want to make certain amendments.
Yes.
I'm not roped because there was a shortage of the ropes for the councils. So let it not be seen by the court that I'm disrespecting the proceedings.
Yeah, you should have approached me before, sir, and tell me about your condition.
Noted.
Anyway, the court allows you, you may proceed.
If it pleases the court, I would like to proceed with the closing arguments on behalf of the applicants.
Both applicants?
Yeah, both applicants.
Thank
Your
you.
Worship.
You may proceed, sir.
The applicants should be granted bail on the following points. First of all, the applicants are not a flight risk. Mr. Mkatani, based on the evidence in chief he has given, he has no travel documents and he has no traveling documents and he has no international ties. Sipa Chauke, even though he has a passport, he already surrendered it to the relevant authorities, which means that he's willing to not leave the republic. The applicant should also be
Before you go to another point, in regard to the second applicant, Mr. Chauke.
Yes.
He said that the last time he went to Nigeria was when he was going to get married 20 years back. And it appears to me that his evidence is to the effect that he does not have any intention whatsoever to go to Nigeria again. Did I understand the evidence correctly?
You understood it very correctly, Your Worship.
Thank you. The state contends that he has updated his passport. Does that not mean that he has the intention to visit Nigeria again?
Even though he updated his passport, the act of him surrendering the passport itself means that he's not willing to leave the republic.
Thank you. Another contention from the state is to the effect that, I just want your comment on that, is to the effect that he would illegally leave the country and go to Nigeria. What is your comment to that?
That is just a speculation, Your Worship. There's no evidence to prove that at this point of the proceedings.
Thank you. May proceed, sir.
The applicants will also be released on bail on the following points also, that their employment contracts are at stake. Their prolonged custody will mean that they will not have any jobs, they will lose their jobs, and thereafter, if they've lost their jobs, it will mean that they will lose income. The effect of them not having any income, it means that they will not be able to support their families since they are primary caregivers in their families and their wives are unemployed. Furthermore, one of the applicants has a child who is in tertiary. He pays for the child's tuition fees, which means that his prolonged custody will mean that he won't be able to pay for the child's tuition fees, and the child's education will therefore be affected. Even if there are arguments made by the respondent, namely the respondent, the state that the child can apply for funding. NSFAS funding is qualified for, and we are not quite sure if whether the child of the applicant will academically qualify for the funding in terms of his performance, the child's performance, if I can put it this way. So, in keeping the applicant in custody, it will mean that they will not be able to pay for the child's tuition fees. Furthermore, Your Worship, in the evidence in chief, it was noted that the applicants do not have any savings. This means that if they are held in custody for a long period of time, their families will suffer. They won't have anything to eat because of there's no income coming into the household. It was also noted that Sipho Chauke, applicant number 2 in this case, is a grade 12 teacher who teaches children with special needs. His prolonged custody will have a negative effect on those particular learners because mid-year examinations are approaching and they will not have anyone to adequately prepare them for the upcoming mid-year examinations. Even though an argument can be made that his post can be filled, the process for employing a person is very long, and by the time another person is employed to fill Sipho's employment position, it will already be too late for the learners to sufficiently prepare for the upcoming examinations. Another reason why the applicants should be released on bail, it is because Sipho Chauke is a visually impaired person. The conditions is placed under in police custody do not cater for him as a visually impaired person. He does not have any assistance when he's in police custody, so it will be convenient or more suitable if he's released on bail and attend subsequent trials coming from home as opposed to coming from police custody. Furthermore, the prolonged custody of Sipho Chauke will have a negative effect on his visual impairedness, meaning that him being placed in custody as stated in the evidence in chief will lead to his eyesight completely diminishing. The court should put itself in the shoes of the applicant, namely Sipho Chauke. Well, if he's denied bail, and thereafter he sits in jail for a period, he sits in police custody for a long period of time, his eyesight diminishes, and thereafter he's declared to be innocent. It will be a complete prejudice to the applicant. So he should be released on bail based on this point also. Another point is that, Your Worship, one of the applicants, namely Mr. Mkajani, is a church member. Him being held in custody for a long period of time will lead to him suffering reputational damage. Mind you, he's a treasurer, Your Worship. So since he's a treasurer and he's kept in custody for a long period of time, what if he's found to be innocent, Your Worship? The church will no longer trust him with the money, and he will be judged by fellow community members. The last point is with regards to the pending Mokopane case, Your Worship. The applicant should be released on, both applicants should be released on bail so that they can adequately prepare for their defense in that particular case, not case, it's a mistake.
So the pending case, is it also a robbery with aggravating circumstances?
The pending case is a robbery with aggravating circumstances, yes, Your Worship.
And they are also now facing robbery with aggravating circumstances.
Confirmed.
Do you think that the court should then admit them to bail based on this pending case and also the fact that they are facing the similar offense?
Well, at this stage, Your Worship, they are still innocent. There are still allegations, these things. They haven't yet been convicted for robbery with aggravating circumstance case. So I think it would have been more probable if the applicants were denied bail on the basis that they committed a robbery with aggravating circumstances case before.
What is your comment regarding how strong or how weak is the state case?
The case against the applicant is very weak, Your Worship.
Why are you saying this?
The weakness of the state's case is that, first of all, applicant number 2, Sipo Chauke, he's blind, right? What are the probabilities of a blind person committing a robbery? They are very less, Your Worship.
What do you mean? I mean, a person can remain in a car and others went out of this particular car, commit an offense, maybe on the basis of common purpose. What are the circumstances that will suggest he did not participate in the commission of this offense?
Well, Your Worship, it will be very difficult to prove that a blind person was committed a crime with common purpose with this co-accused in these circumstances, because even though he might have waited in the car, he might have not been knowledgeable.
I didn't say he waited in the car. And I was just giving you an example.
Oh,
there is no evidence before court that he waited in the car.
Oh, I was just answering based on.
I'm sorry.
Yeah.
Thank you.
Is there I was asking whether there's.
Oh, you say the evidence in terms of the state case based on the affidavit is that there are eyewitnesses who have identified the applicants as culprits in this case. Do you still maintain or persist that the state case against them is weak?
I still maintain that the state case against the applicant is weak based on the following points, Your Worship. The evidence given by the witnesses with regards to the robbery case is still going to be evaluated in the trial court, and the trial court will determine if whether the evidence given by the witness is reliable or not.
Can this court entertain a trial? Can it be the trial court?
This court cannot be a trial court, Your Worship.
What will the reason be?
This is a bail application.
Yes, I know it's a bail application. What will the reason be that this court cannot try this matter?
Well, the court will be risking dealing with an issue that is going to be dealt with in the trial court.
Any one of the councillors that can help you? Yes, ma'am. Remember, I'm asking you this because you say the trial court is still going to evaluate the evidence against the applicants. And I've also asked you a question as regard to the fact that how strong or how weak is the state case? Do you understand what I mean? Thank you, ma'am. You may proceed.
Thank you, Your Worship. In regard to the first accused, the first applicant, so Mr. Mkajani, I do not recall when the prosecution was reading out its affidavit expressly stating that they saw him possessing a dangerous weapon, because one of the definitional elements of the offense of robbery with aggravating circumstances is the fact that he should possess a dangerous weapon. Furthermore, my worship, are further likely to state the fact that as much as bail might be a preliminary hearing, and we also acknowledge that, but we strongly believe that by the fact that my client was once arrested, he has already suffered a specific form of indignity. Furthermore, in terms of the first accused, when we have been giving evidence in chief, we have expressly stated that he's been confined to shared custody and he has been able to abide by it, which shows that he is capable of abiding by the law. And furthermore, the court will not have assigned him shared custody to often have contact with the children if he was a habitual criminal or a dangerous criminal, since that will not be to the best interest of the children. Thank you.
Thank you, ma'am. You said that the state did not mention in the affidavit that the applicants were found in possession of a dangerous weapon.
Yes.
Paragraph 9 of affidavit states that the employer at the shop was forced to open the safe to two robbers after they have threatened to kill her by pointing guns at her. Will that not comply with the definition of aggravating circumstances in terms of Section 1 of the Criminal Procedure Act?
Okay, it does.
It does.
Yes.
Thank you. Is that all? Thank you. Oh, you still have something to say, ma'am?
Yes.
I see you are raising your hand.
Yes, I still have something to say.
Yes, you may proceed.
As much as I agree with you that perhaps I did not listen to the affidavit in its entirety, sincere apologies for that. As much as I agree with you that what has been stated does confirm the definitional elements, my question is, they did not expressly state that between the two parties who possessed that dangerous weapon.
Between the two of them?
Yes, who possessed the dangerous weapon.
Thank you, ma'am. Is that all?
Yes.
Thank you. State?
Good morning, my lord. My name is Lolamola, and I'll be representing this. I'll be doing the closing statement for the state.
Yes, ma'am.
As presented in the evidence, my lord, the interest of justice in terms of Section 60, subsection 4 of the Criminal Procedure Act do not permit the release of the accused on bail. We have proved, among others, that exceptional circumstances do not exist. The onus was on the applicant to prove exceptional circumstances in terms of Section 60, subsection 11A of the Criminal Procedure Act. We submit that the applicant did not prove exceptional circumstances, and that is, and that his exceptional circumstances, that is the first applicant, that is, exceptional circumstances are rather ordinary or common. And by that, we are directed by the Supreme Court of Appeal in State v. Scott Crossley that personal circumstances which are really commonplace cannot constitute exceptional circumstances in terms of Section 60, subsection 11A of the Criminal Procedure Act. Your Worship, the applicant in his evidence in chief provided to the court that he is an accomplice in the charge. He believes to be an accomplice in the charge. That he was at the scene of the crime without
Which
his knowledge.
charge was he referring to? Was he not referring to is it the pending charge?
Oh, is the pending
Yes,
charge?
I think he was referring to the pending charge,
charge,
not
okay.
the charge that he is
Okay,
facing.
Apologies, my lord. I might have missed that. Okay. The applicant, the first applicant in his exceptional circumstances mentioned that he has 2 children and their mothers are not working. Though I believe, my lord, that the mothers and the children can receive financial support from the government. The government has made in place unemployment grant as a response to COVID-19, and also there is child support grant. He is not married to their mother, so I don't believe the nature of his employment can be a hindrance to the children qualifying for child grant. And I'm of the opinion that the combined grants may not be enough to match his support, but I believe they can go a long way in helping in his absence. Again, my lord, he mentioned that he has a grandmother who is ill, who needs attention, who needs assistance. So, my lord, I believe that the mother, since he's working, he does not provide that assistance to her mother for her daily basic things. So that means he supports his grandmother financially. Now, for financial support, I believe the grandmother can apply for pension fund and receive the pension from the government. Also, alternatively, he can go to the old age institution provided by the government in the absence of the applicant.
Pension fund, which pension fund are you referring to?
No, my lord. I meant, apologies, my lord. I meant old age grant.
Old age grant.
Yes,
Thank you.
Apologies for the mix-up. My lord, the applicant has a pending case. Has a pending case of the same nature of the current charge. He was released on warning and yet committed the same crime once again. This, my lord, such a conduct undermines the values and objectives of the criminal justice system. And this will prompt the commission of other crimes, I believe. Now, since he was given a warning and he committed another crime, letting him off again on this current charge is a risk not only to the criminal justice system, but to the overall society. Because with every crime he commits, my lord, people's lives are in danger. Again, another fact about the applicant is that he does not have a fixed address. He established that his fixed address is where he stays at Mankweng, the residence which is provided by the Department of Social Services. But my lord, he mentioned again that he is renting that place. So that is not his permanent residence. And thus I don't believe it can be a fixed address. He can move out anytime.
For how long was he employed?
He mentioned 4 years. He mentioned that he was employed for 4 years.
For 4 years?
Yes. Yes.
Is that correct? Yes. Will you think that he will risk, he will resign from this employment in order to avoid this particular case?
No, my lord.
He won't?
I don't believe he can resign, but I believe he can find alternative places to move to. As he has adduced to the court.
Will you then be not able to find him at work if he cannot resign? If he does not have a fixed address, as you argued, does the state not know where he is employed? Will it not be easy for the state to go and find him at work?
I believe it is possible.
It's possible.
We cannot be certain for sure, my lord.
If that is the case, will you still maintain that he is a flight risk?
Well, he may not be a flight risk, my lord, but I believe it will be hard for the court to attain his presence for the trial.
Or he may not be a flight risk?
Yeah, because even in attaining his arrest, he was nowhere to be found. His arrest was held by the second applicant, so I believe it may be harder to obtain his presence for the trial.
Is that all?
No, again, the first applicant mentioned that he's a church member and has a prominent role in his church. He is a treasurer. So I don't believe that that is an exceptional circumstance. A treasurer can always be replaced or someone be delegated to for that position.
Mm-hmm.
So I believe that, my lord, is not an exceptional circumstance. My lord, again on the first applicant, he was released on bail on the pending trial, on the pending case, and yet again did not comply with the conditions of the bail. He committed another one.
What was the conditions?
Well,
because I'm not aware about the conditions of that bail.
But I believe that when you are given bail, you have to report to the police station timeously. You have to stay.
Are there any conditions attached to that, or it is what you assume?
At this stage, my lord, is what we assume. That.
So you don't have facts in as far as that case is concerned?
My lord, I believe one of the conditions of bail is not to commit another crime. And the applicant committed another crime. So he did not comply with that, and I don't believe that he will comply with the current bail conditions of this trial. And this also goes to show that he does not respect the law. As I have mentioned, that he undermines the values and objectives of the criminal justice system.
Is he not entitled to be presumed innocent until he is proven guilty or otherwise? I'm raising this issue because you say he is undermining the law.
Well, he is, my lord. He can be presumed innocent. But looking at the law, the South African bail law, the law have tried to ensure that bail is, when bail is granted, the circumstances, they balance the risk between the society, the society's interest, the rights of the victims, and the witnesses and the criminal justice process, and that of the accused right to be presumed innocent. And thus I believe that since the applicant has committed the crime before, he is more than capable of committing it yet again. And that, my lord, I believe, if released, is a danger. He is a threat waiting to explode, my lord.
Mr. Lamola, I have read the affidavit by the investigating officer. It says that 2 robbers entered into this shop and pointed the victim with firearms. It does not disclose who these robbers are. How do you link the 2 applicants as being the robbers that are referred to in this affidavit?
If I can get the question your worship is asking is that
how do you link?
Do I link
the
first
the
applicant
2 applicants as being the robbers that the affidavit is referring to?
My lord, the gun which was...
I'm sorry?
The gun, your worship, the gun which was used in the commissioning of the crime was found at the applicant's place. That
Is it in the affidavit?
exactly the,
In which affidavit does it indicate or disclose that the gun that was allegedly found was found? Can you give them the affidavits, please? Court orderly, give them the affidavits.
okay, my lord. If the court pleases, I may ask to consult with my
Yes,
co-counsels.
yes.
and
You may also refer to the affidavits.
affidavits, yes, court.
Maybe there is something that I do not see in the affidavit.
Apologies, my lord.
Yes.
It seems the investigating officer may have not adduced or attached the fact of the gun on the affidavits, and thus I apologize on his behalf.
So there is no evidence before this court to the effect that there was any gun or anything that resembles to
Well,
be a gun
Your Worship,
found in possession of the applicant.
Your Worship, it may not have been disclosed on the affidavits that the gun was not there, but it was, and I do have proof, and the gun was confiscated.
Yeah, but
and stated that the gun-
will not that mean you are adducing evidence from the bar?
from the bar.
Yes. Are you not adducing evidence from the bar now? Because the state elected to adduce evidence through an affidavit.
Yes.
The affidavit that has been compiled or written by the investigating officers.
Yes.
Therefore, the affidavit should disclose all the facts that the state will rely on in this particular bail application.
That is correct, my lord.
Thank you. That being the case, was there an identity parade held?
Was there
Identity parade held?
identity parade?
Yes, by the state, whereby the victims were able to identify the robbers.
No,
I'm asking
no,
this
no,
because
my
I
lord.
have a problem
No, I don't-
regarding the affidavit itself. If it only refers to the robbers, not identifying the applicants as the robbers.
Pardon me, my lord. I believe there was a witness for the crime, and
Yes, thank you. Yes, yes, please.
We are extremely sorry that we were not able to adduce full evidence of the affidavit on behalf of the investigating officer.
Yes,
There are two documents that were attached to the affidavit,
yes.
but due to the fact that the documents were not stabled, they were somehow
Yeah, which documents, even if they may be attached, are they being referred to from the affidavit? That I refer to this particular document, I refer to exhibit so and so. Is there any reference from the affidavit to the said document that you are talking about?
Unfortunately, my worship, it was not properly referred to the affidavit. It should have been referred to the affidavit on the section where there was an eyewitness who was pointed with a gun. As we have been able to trace and locate the gun. We have in our possession the picture of the gun,
Yeah.
together with the picture
I have
of
already
this.
said that that will be adducing evidence from the bar. Not so.
It is so, my worship,
Thank
and we
you.
apologize for that.
Okay, fine.
And-
If that is the case, how weak or how strong will you say the state case is, based on all these deficiencies that I have alluded to?
I profusely apologize, Your Worship, for not.
What you must argue, not
not-
apologize.
Yes. Okay, Your Worship,
This is-
the state case is very strong, as we have evidence leading and placing the applicant number 2, to the crime scene.
But I don't have that evidence in this bail application. That is the problem. Because the court will make a decision based on the evidence, based on the facts that it has, not evidence from the bar by the counsels. Is there anything further to say?
No, Your Worship.
Thank you.
Thank you.
Oh, yes, Mr. Lamula?
Yes, it is mentioned that there is a footage which shows the first applicant with the second applicant. So I believe the
There is a
footage.
footage.
Yes.
But still, is the footage in the affidavit? Do you have such evidence in the affidavit, Mr. Lamola?
No, my lord, it doesn't go with the affidavit. No. No, my lord, and I apologize for that deficiency. Apologies.
What is it that you want to do, State?
As my lord, a deficiency was established in our documents, I would like to move with the case to not waste the time of this court, of this honorable court. And yes, I would like to move, my lord, move on to the next point.
I'm sorry?
I would like to move to the next point, my lord.
Okay, you may proceed, Mr. Lamola.
Your Worship, the first applicant mentioned to this, the second applicant, apologies, mentioned to this honorable court that he has a passport and he has been to Nigeria before for purposes of marriage. And his Nigerian relatives, I believe at this stage, acknowledged him and in time of need may accommodate him. Even though he may have submitted his passport to this court, to the relevant authorities, I still believe there are alternative ways in which he can get to Nigeria, as much as there are Nigerian illegal immigrants in South Africa. Another fact, my lord, is that the second applicant has a previous charge of assault. He is a previous charge of assaulting his neighbor. So I believe he is no saint in the eyes of the law. And this proves that he is someone who is aggressive. And I fear that he might use this aggression to intimidate the witnesses if to be released. My Lord, Your Worship, the applicant mentioned his wife. He mentioned his wife and his children, and that his wife is not working. So I believe she can also, in the midst of applying and seeking employment, he can apply for the unemployment grant, so that he can help in catering the needs of the kids, and also helping him find transport to go and look for employment. Because I know that in South Africa it is one notable matter that most people can't find employment because of the lack of transport, the lack of transport money to look for employment. So I believe we can use this to find employment in the absence of the applicant. And Your Worship, I'd like to plead with the court that should his bail application be successful, let it be a bit exorbitant to serve as a deterrent. I believe half of his salary will be enough to make him think twice before transgressing against the law. It is that I believe that exceptional circumstances were not well established and proved. So I plead this honorable court not to honor the bail application of the applicants, and let this serve as a deterrent and means of protecting the society. Because as I have mentioned, my Lord, with every crime they commit, people's lives are in danger. As such, I contend.
Thank you. Thank you. Is that all? Thank you. Thank you. Thank you. Do I have to give judgment? Or constructive feedback?
If your worship is ready, we humbly request that if your worship is ready, otherwise we can move it to, because we still have 4 items on our agenda for today. But if your worship is ready, we humbly request that perhaps you give what would have been your ruling, and the strengths and weaknesses, and your observation, your general.
Okay, let me just comment.
Yes,
or
while
give
state, of
you
course.
a constructive feedback. What I can say is that we should, all of us, applaud our participants. I will start with the counsel for the applicants. I am very much impressed about the way in which they have led the evidence, leading their witnesses. They have covered everything what has to be covered in the bail application, the personal circumstances of the applicants. That is very, very, very much important. All of them, I have observed that they did prepare. What is very important is preparation. And if you have prepared, you will not have any problem with your case. And even the argument by the counsel, it shows that he knows his case. He was just articulating his position without even reading perhaps from any document. That is a clear indication of how preparation is. What is important is that when the court asks you questions, you must be able to a certain extent to respond, and you must know all these matters. For instance, let's take the issue of the agent bail the agent application for the court to allow the use of the media. There are requirements for the agent application. I will not go to that because you were not prepared for that. Otherwise, you would have been in a position to address the court on the question of agency, when was it? Saturday, I was watching a TV when there was an urgent application brought to prohibit certain branches of certain organization to participate in the conference. The issue of the agency, the judge raised that particular issue to the extent that he said, you waited for a long time and now you are approaching me on the basis that this application is urgent. I find the application to be, the agent to be self-created because you waited a long time, not brought this particular application to stop the participation of certain members in that particular conference. The affidavit. If you lead evidence by the affidavit, there will be no cross-examination on that particular a person who made the affidavit. Like if they decided to lead evidence through an affidavit, you will not have been in a position to cross-examine the applicants. The same applies to the state. This is a practice that is used commonly at our courts, whereby the state just bring an affidavit. And you find that in the affidavit, it is not more detailed. What is important is to approach the evidence which is before court to determine how strong or how weak the state case is. In other words, as a presiding officer in a bail application, I still have to apply my mind whether the evidence against the applicants is strong or is weak. I will only be able to do that if I am told how they are linked to the commission of the offense. The reason why I asked the counsel why I cannot do a bail application was on that basis. I should hear the merit of the case to a certain extent. That is why I cannot hear the trial, because I heard the merit of the case. Yes, the affidavit says that 2 robbers entered into this particular shop. They pointed the victim with a gun. But who are these particular robbers? They failed to disclose that it was applicant number 1 and number 2. In the first place, I will assume that they did not know them. And if they did not know them, I will expect that there will be an identification parade. And I will also expect that there will be evidence from the state to say the way we link this particular applicant is because of the fact that the witnesses have gave us a description of this particular witness, robbers. We were able to go and arrest them. You talked about the what is that? The firearm and the documents that were supposed to be attached to the affidavit. Even if the documents were supposed to be attached to the affidavit, but because there is no reference by the investigating officer to say, we followed a lead and we arrived at applicant number 2 house. We searched, we found a firearm that was alleged to have been used in the commission of this particular crime. That should be the evidence. But I am happy, ma'am, about the cross-examination. It was very good. I am happy also about cross-examination. It was very good because the purpose of cross-examination is to discredit the witness. So the questions that you were asking wanted to show that the witness, you are going to push that the witness must not be admitted to bail. And also the questions by, who was the other counsel? Cross-examination. No, cross-examination. Oh, it's you, Mr. Patlane. The questions was, you wanted to show that you are a flight risk, particularly regarding the issue of passport, because you even said, no, we have a passport, you updated the passport, but now you tell us you have been in Nigeria for 20 years. The reason that you updated the passport is an indication that you wanted to fly to Nigeria. So the intention of wanting to fly to Nigeria is a clear indication that you may be a flight risk. So you must be able to cross-examine in order to come and support your argument. Other than that, I am very much pleased. I am so impressed by the arguments, and all are engaged. The councils, they are in a position to respond to the court. This is what is very important. If I established that the state case against the applicants is strong, I will not grant bail on the basis that they have a pending case of similar in nature. If I establish that the state case is so weak that the evidence of the state is lacking against the applicant, in my view, irrespective of whether the applicants have previous conviction and other pending, that may, to a certain extent, be a strong factor in favor of the application by the applicant because of the fact that the state case is so weak. But it appears that the state case is strong, but the evidence was not placed before court. It's very important for the evidence to be placed before court. And if that is the case, the court will then say, no, the state case against the applicant is strong. I'm not saying the applicant have committed the offense. Remember, the bail application court cannot make a finding to the effect that the applicants have committed an offense. The bail application court may say, I find that the case against the applicants is very strong, and that being the case, this is a Schedule 6 offense. I have considered all the factors that the applicants have adduced, but the fact that they have a pending case of robbery and again go and allegedly commit another offense of robbery, which I believe that the state case is strong, I find under the circumstances that I may not admit them to bail. I find that maybe the case, I have already indicated that the weakness of the state case, I may, to a certain extent, grant them bail. This is my observations. Thank you very much. Oh, we are still going to proceed. Oh.
I haven't given permission yet, Prof. I'm surprised you're already there. But anyway, we welcome, I've already said about the Honorable Director has joined us. And Honorable Mantata, I was saying we have few items. So if you can just perhaps indulge us and relax and observe how we do things here. There are very few. I hope the people that I'll be asking to do certain things will do it as shortly as they can. It is my plea. Please. Now we move to the fourth item. We're going to ask Professor Lawrence Rapulana to lead from the front as always and award our participants a certificate because your performance was very outstanding and for your commitment. You were very committed, and Honorable Mantata has already said that he commends you you did a very good job. So do not panic. I saw you panicking. You were panicking and you were losing focus, and I kept on sending notes and you were not reading them. They were actually going to help you. You did. Remember, the purpose of this is to learn and learn and learn and learn and learn, and practice makes perfect. So please, Prof, can you do the honors? Are you going to do it from there?
The suggestion is that maybe let it be the last item, so that once you give them the certificate, we are closing. So
All right. Can we then? Thank you. Let's move quickly to the chair of the Law Student Council, Mr. Malachi. Please give us your few remarks. Thank you.
Thank you very much. Good morning to everyone, rather good afternoon. The Honorable Mantata, thank you for gracing us with your presence. We really appreciate it. This wouldn't have been a success if you weren't here. Thank you very much. Professor Rapulana and your team, thank you very much for the event, for the program that you have established for the students. We're really grateful. Director of the school, you're welcome. Thank you very much for gracing us with your presence. And to the participants, congratulations. I think we should give them a round of applause. You really did yourself proud. You should be proud of yourselves. I'm sure that we all are proud of you. You spoke with boldness and understanding, and it showed that no, you were really committed to what you were doing. I'm just going to say a few things. This program that we had today, it's a really important program, especially for all law students. So I challenge the school and the University of Limpopo to make this a permanent thing, and rather not be reduced to just a program, but be incorporated into the curriculum. I mean, Section 29 speaks of the right to education. It not only speaks about the access, but it speaks about the quality and the relevance. So the word used there in Section 29 is progressiveness, and it means thinking forward in an innovative manner. So I believe that this being something permanent is going to greatly be helpful for everyone, especially the third years and finals years. But with that being said, thank you very much. And I acknowledge the presence of the students who are here, who came to observe, and I hope that you have learned, and that you too next time be encouraged to participate in such a program. I acknowledge the presence of the leadership of the Black Lawyers Association Student Chapter, the South African Women's Lawyers Association Student Chapter. Thank you for coming. And to the LSC, thank you. And thank you, Professor Rapulana, for involving us as the LSC and putting in our suggestions to the program. Thank you very much.
We thank you, Prof. Do we allow the Honorable Director to give us his remarks before? Okay, we thank you. Honorable Advocate Mashele Rapatsa, can you please address your village?
Okay. Good day, good afternoon, good morning. Whatever is applicable to you. And how are you doing? That's wonderful to hear. Well, I came here a lot earlier, but I struggled to get in because I learned that there's only one entry point, and it's in front. So I was worried that the dominus litis would not be impressed with me getting into the venue in that manner. So that's why I decided, well, let me just wait until you are done. But I was following the proceedings from the point where I was standing. By the way, this is 2022. Who was dominus litis? 2022. Okay, who is in the mainstream? So it means in 2019 you were in your first year. Right? Huh? But why is that the case? Because as far as I know, if my maths treats me well, 19, 20, 21, 22. It's 4 years.
No, I've taken the combination. I've taken them from second year, third year, and fourth year. In
Oh.
order to build for the future.
Oh, okay. No, that's fine. But then, do we have somebody in final year from the dominance leader side? Okay. You know why I'm asking this? It is because, you see, in 2019, she was in first year. Right? And her arrival to the University of Limpopo coincided with the introduction of this program. Remember, we held one in 2019, but then due to, at the time, unforeseen circumstances, we could not have one. We could not continue in 2020 and 2021, unfortunately. But then your presence here is very special because then as you exit the university, you'd be able to say to others, this is what I've learned from the university. You see, you leave the university not being a raw material. So I needed to say that before forgetting it. To the Honorable Magistrate, Mr. Mantada, it's always our great pleasure to have you here. And we really are highly appreciative of the fact that every time we ring the bell to say, come and see your children, you come running. He's not even based in Manguing, for goodness sake. He's based some kilometers afar from here. But every time we give him notice that we have this kind of an activity, he does not shun us away. He always makes time to come and be with you. Why is he doing that? Because the University of Limpopo has a very rich history, if you like. Very rich and reputable history, especially in as far as the legal professionals are concerned. It's impossible for you to get past any entity out there without meeting a law graduate from the University of Limpopo. You can talk about your courts, the lower courts, high courts, all the way to the Constitutional Court. You will find a graduate of this university in the School of Law. You can go to your NGOs, your SOEs, your government entities, you'll find them. And how is their performance? They are excelling, right? So what does it mean now to those that come after them? It means you owe it to them. Because that legacy is what keeps you respected, by the way. The School of Law, because of that legacy, that heritage, still holds that reputation and respect among a lot out there. So you cannot afford to let us down. And I'm very happy that by virtue of your presence here today, you've decided that you are going to take up the challenge and be part of history in the making. And we want to congratulate you for seeing this as an opportunity for you to participate in what we call experiential learning. You learn by doing, you learn by act. And I can assure you, this is something that will live in you for years and years. And you'll even see when you exit the University of Limpopo, when you get out there, it would not be difficult for you to integrate in the real world of practice. Because at least you shall have been exposed. And all thanks to activities such as this. When this was conceptualized in the beginning, the idea was that we would be doing it on a quarterly basis. Remember, that was immediately after we reclaimed our full accreditation of the LLB program at the University of Limpopo. And part of the commitments that we made to the Council on Higher Education was that we would be exposing our students to experiential learning on a regular basis. And that's why, come 2019, you saw the introduction of things like this, a mock trial, the moot courts. And according to our plans, we need to be having this at least at a competitive level. This is at a competitive level, right? We need to be having this on a quarterly basis. like Tabelo is saying. That was our idea when this was conceptualized. And we hope that we'll be able to do it as we proceed. It's a pity we could not realize that in the past 2 years because of COVID restrictions and so forth. But with things easing down a bit, we hope that we'll be able to realize that dream. To Professor Raplan and the team that organized this, the school is quite heavily impressed. And we are saying all the praises to you for being patient. Because our students are students. Sometimes they are not on time and all that, but you have been patient, and that has paid off, in my view, because you can see the outcome is a positive one. And by the way, if you did not know, you are now trending on YouTube. For your information, you are trending on YouTube, and that's why you can't afford to be funny. So even when you live here, you have got to be working like legal practitioners. And when somebody asks you things, then you respond in a manner that indeed speaks to what you are. And I hope this now becomes a cultural thing in your minds and in everybody else. Obviously, we understand not every student will have been able to be here, but you are here for them. And as you go out, you'd be talking to them as well. That this was quite a fascinating experience. This is what we have learned, and this is how we can impart it to those that are senior students. Can impart this same knowledge to the junior students and all that, and it becomes part and parcel of what we do at the university. It was there, by the way, in the past. And that's why you see people like Honorable Mantara being special out there. Because when they are sitting on the bench, when they speak, you can see they know what they are doing, because it is in their blood. Right? So I hope that you would accept this as a challenge to continue to be special. You know, I need to say this now, in conclusion. For a very long time, law students of the University of Limpopo have always been playing this critical role of being inspirations to everyone in the campus. I'm now going beyond the school. Even I'm talking about students who are in here. Understand this environment is used by water and sanitation students, geology and others. There's always been this element that law students are role models to even students who are not in law. But things have since changed. Why? You have to sit down, ask yourself, where did we get it wrong? Why have things changed? I'm just going to give you some of the things which would be food for thought. It's a homework. Our attitude. Our attitude. Sometimes we do terrible self-destructive things without realizing. For instance, we prepare a test timetable, we distribute it. Maybe 3 weeks before the commencement of assessments. And just a day or 2 days before the assessments must commence, there's these two guys who just don't like studying. They have not been preparing, they have not been doing anything, right? But because they speak the loudest, they come and incite others that no, we can't write, the timetable is congested, is this, is that, is that. Right? You get away with it. You think that's the way to go. You see, in the process, you lose that special position that people have had for you because of your attitude, your tendencies, your shenanigans. Right? I know most of you who are here do not do those things. But the fact that you allow it presupposes that you are agreeing with those tendencies. And it is costly for you. Are you with me? So I'm saying to you, I want you to start challenging this. It must come to an end. We are not allowing it anymore, by the way. We have taken a position, it can't happen anymore. If you decide you are not going to start, you come on the 11th hour, please postpone Warwara. That's not going to happen in the School of Law, not anymore. It's a game. And games must come to an end. We're not allowing games anymore. We will allow these things. You see, if we see a lot of you in these things, we will become friends, very good friends. But disruptions, a day before, no, we are not ready. No, but why are you not ready? It means you are not serious about university. Go home. Don't disrupt other kids who want to be here, who want to do mock trials, moot courts, and so forth. Because activities such as this should be our focus. We are here for this. And when you leave university, you should be having you should leave with something to be proud of. And that way would not even be ashamed to associate with you, because we know that this is our product. This is somebody that is going to represent us in a good light out there. So I hope from now on you are going to participate in the process of eliminating tendencies. We don't want tendencies. We want excellence. Excellence should be our mantra. We want to run with that all the time. Right? Undertaking. Undertaking. That yes is not coming out strong, but I know you are agreeing with me. Yeah, okay. So, Honorable Mantada, Professor Abulani and the team, and litigants, we appreciate your presence. You are making us proud. You are making us shine, by the way. So, you shall have a good day. Thanks.
Thank you, Advocate Ragubu, for running the program. I also want to convey my gratitude to the unsung heroes who have been with me from day one and to this day. And as you have heard from the director, this event was broadcasted on YouTube and therefore you are a subject of discussion. Today, this day is not about me. I have various platforms and opportunities where I can speak and do whatever I want. This event was about you, the participants. It was meant for you to have a taste of what is happening in court. I can assure you, somewhere in second year, third year, you've already appeared before a senior magistrate, before you can even complete your degree. That is an achievement. You have already taken a senior magistrate lead argument. Some of us, we never have that opportunity. We completed the junior degree and even the postgraduate degree without even having appeared in court, without even having seen the courtroom. So when we make these opportunities available, please utilize them. When we started, we were more than 30. But I knew, that's why I always take the larger group instead of taking 4. Ordinarily, I would have taken only 4 people, and close. But I know that the number of people that are going to fall through the cracks, there won't be any commitment. So this program can only succeed if the students, they commit themselves. And for that, I want to thank you and award you the certificate. I normally don't sign certificate. At the end of the year, the final student will be coming to me to say, write testimonial letter. I always say to them, go to the director, Advocate Rabaza. I'm not doing that. I never write any student a testimonial letter. I never sign any document for a student. Because most of them, they are not trustworthy. When you need them, they are not there. So, but for this event, because we have been there, yes, I've now prepared the certificate, and even if you want testimonial letter, I'll be ready to sign. But not for everybody who just come to my office on the day of need. So thank you. I'm going to invite our Honorable Magistrate here in front and the director, and you can even join us, the program director, and then I will call them one by one, then we award certificate. Ramahoha, are you ready to take them photo quickly? Because I'm going to switch the mic. You can call, okay, maybe let me call them so that I remember that. In no particular order, I didn't put them in a particular order. So I'm going to call VL Mbofana, come to the fore.
How are we doing it?
Okay. Maybe I'll give it to the moderator to hand over.
Okay.
Okay.
You look that way so
You-
that
you look that way.
picture.
And look at that picture. One picture will be enough. TM Mugala. TM Mugala. Oh, you see, I'm going to take off because I write on that list. Oh, okay. Remember, she might not have appeared, but she was part of the team from the beginning until the end. So we really value her contribution. So you mustn't be ashamed of yourself. You are part of us. Go that side. MV Jones. You want me to go that side? All right. T.S. Mashadisa. T.S. Mashadisa. Oh, sorry. My apologies. And Apani. LL Mafungo. And someone must be ready to bring Sipo Chauge. Waiting for Sipo Chauge. Oh, I say Sipo Chauge. My apology. Wait for him. Wait for Sipo. M.E. Mama Wolo. That's M.E. Mama Wolo. El Pakula. V. Bimalaji. V. Bimalaji. She forgot her name. It happens. Zadintsieni. Zadintsieni. Did I print by mistake? All right. I will return it. K. Emracheni. MP Babale. Esla Mola. Mkachane. Sekula. Dubuo, come to the fore. It looks like I've omitted your name. But let's take the photo, then I'll attend to the certificate. Bring Dubuo. Please assist Dubuo. Bring Dubuo to the front. Yeah. Can you assist her to come to the front? The certificate, I'll fix it. Remember when I asked you to write your names, and then you didn't put all the names there. Who else is forgotten? Because we want to make sure that you have a photo. All right. No, that is not support. Okay. Okay. Come in. The police officer, come. I will print. Dubuo, you can take Dubuo. I'll fix the certificate. Yes?
I wanted to suggest that since the camera cannot see the name, maybe you can give, if you have any certificate.
Oh, any certificate. Oh, okay. All right. Thank you for that. Thank you, Advocate Magambi.
Yeah, except that it's not accurate to say the camera won't see the name.
All right, come. Police officer, let's use this one. Yeah, Dubuo, you can leave. Take Dubuo.
And what they do is, maybe they can also take a picture, all of them together.
Yeah, we have already, okay, yeah.
You have taken?
Yeah, before.
With certificate?
Oh, without certificate, all right. The police officer will give me the name, I'll fix them in office. Yeah. And the assistant police officer. Court order. Who else here? Come. And the last participant. Ladies and gentlemen, my work is done. Oh, there's another one. Oh, sorry. All right. Yeah. Yeah, this one will tear. Yeah. All right. Thank you for everybody for being here. Thereafter, there is a lunch served, I think it's nearby here. And then everybody will get the lunch. We'll allow the participants to eat, and then the staff members will go to that boardroom. We'll have our lunch there. The audience, there's also lunch. The ones who allow the participants to serve themselves, and then you can then follow them. My work is done. Over to you, the program director, and I want to thank everybody for you to close.
We appreciate each one of you, and especially Honorable Peter Mantata. We cannot have had this occasion without him ushering us with his presence. You know, time from Mudimulle, it's so far, he's always committed, like the director has said. Each and every one of you, we really appreciate you taking your time to be here to complete this august occasion. Thank you very much. Please have your lunch before you go. Thank you.
And my council office, yeah, you must bring them to the office. I didn't bring the car, so you must help me to get them. 1, 2, 3, easy. All right.
Someone else, please. Someone else, please. Sure. Someone else, please. Okay, but okay, before you guys come in, if you guys want to get in that one, let's go back to the let's keep the and you don't really have to mention those down to out. But let's say time. Let's say time. Let's say time. Guys. Let's move. Okay. Okay. 51. Someone missing there. Okay. There. Hold on for me there. Thank you. Let's mix it around. Ladies, are you coming? Okay. Let's move to the Friday. Okay. Let's do what is doing over there. Let's get on. Okay, give me something else here. Yeah. Okay. That's nice. Thank you so much. Okay, this is the last picture now. Okay. Okay, let's try this one. It's not coming up. Hold on for me. There we go. Thank you. Thank you guys. You can go out. Let's have this. Okay guys, let's move.
That's
Yeah, let's try. Sisters, how long are you coming here? You can try now. Okay, yeah, let's try, guys. Come on, Shapa. Are you guys okay? The Shapa. Yamara, open the front space. Yeah, the Shapa come. Let's try. Yeah, I think it's okay. Okay, can you face the camera? Do whatever it's doing. Yes, perfectly so. Okay, you can spice it up with some nice poses there. Okay, let's have fun, more fun of that. Perfect, okay. Right, now let's introduce the small groups. Can you do one here and then you Okay. So we'll do the one first, right? Okay, let's move, okay. Right. Is that how you call it? Okay, I put you there, okay. Okay, I put you there. Right, can someone else do something next? Remember, you just have to go the way you want. Thank you so much. Someone else just come. Right, bring the camera. Someone else please. Hang on. Next.